Good afternoon, and welcome to AlvaradoSmith's presentation of coronavirus and California employers, what you need to know. Before we get started, I first wanted to extend a deep and sincere apology for those of you who attempted to log in this morning or today at noon for our first issue of this episode. We've been experiencing some significant technical difficulties with GoToWebinar and GoToMeeting. They are understandably jam-packed full of people trying to use their service today as everyone is trying to work from home. It appears that several dozen of you weren't able to join in the conversation, or were only able to hear the conversation and not actually see the slides on the screen. If that is still the case, we continue to apologize. And if you shoot us an email at the end, we can send you a copy of all the handouts and a copy of the recording of the presentation. By way of introduction, my name is Jonathan Werner. I'll be your presenter today, along with my partner, Ted Bacon. Just to give you a little bit of information about us. We are management side, labor and employment attorneys. We're both partners in the employment services group of Alvarado & Smith. Alvarado Smith is a full service firm with offices in Orange County, Los Angeles, and San Francisco. I reside in the Orange County office, and my partner, Ted, is resident in the San Francisco and Los Angeles offices. So with respect to the presentation today, if you look in the handout section of your dashboard, you will notice 3 documents. One is a copy of these slides. One is a copy of the Governor of California's emergency declaration from yesterday. And one is a copy of a document from the federal government listing core industries or critical industries that are required to stay open during the shutdown. So we will be referring to those documents throughout the course of the presentation. We just want to make sure that you have those easy in hand if you need them. You will. In addition, if you have any questions about today's webinar, please do not use the question or chat feature in GoToWebinar. I'd ask that you please send an email to webinarquestions@alvaradosmith.com. webinarquestions@alvaradosmith.com. That's an email account that we have established for purposes of answering these questions. It's much easier and more streamlined if we have all those questions funneled into one inbox. Please do include your name, your company name, and your phone number along with your question, just in case we need to reach you in some way other than by email to answer your question. We will do our best to get back to you as soon as possible. The presentation we're giving you today is, in fact, much different than the one that we were planning on giving you yesterday, and that is because of Governor Gavin Newsom's executive order of last night, March 19th. That's Executive Order N33-20. I'm sure most, if not all of you, are aware of this executive order, perhaps even tuned into YouTube or the local news channels and listened to the governor issue the executive order. What this order does, I want to spend some time going through that. It reaffirms the state of emergency that the governor declared on March the 4th of this month. In addition to that, it goes much further, and it now has issued a stay-in-place order, which means all individuals living in the state of California are ordered by the governor to stay home or at their place of residence. We call that a stay-in-place. There are some exceptions to that stay-in-place order. One involves essential services. Those will remain open throughout the course of this declared emergency. Those services include things like gas stations, pharmacies, grocery stores, takeout and delivery restaurants, not dine-in, those are closed, banks, things like laundromats, all of the normal services that we as human beings need to survive on a day-to-day basis. It is very clear, as you notice at the bottom of this slide, this order was written very quickly. There will likely be further clarifications to this order as the days and hours go by. But again, we are dealing with an unprecedented emergency, and we can all recognize why the governor felt that he had to get something out quickly to advise all of us. So what is closed? I touched on dine-in restaurants. Those are closed right now. So are bars and nightclubs, entertainment venues, sporting events, gym and fitness studios, any public events and gatherings. Convention centers are closed. Question we are frequently getting now is, when will these restrictions end? There is technically no end date to the restrictions as set forth in the governor's executive order. They will remain closed until further notice. Another question we are frequently getting now is what happens with respect to these more restrictive local orders that counties, especially the counties up in Northern California, have issued. Our perspective on this is that they are not preempted. They are not preempted by the governor's order. And so if you are subject to one of those stricter regimes, that our best advice to you is to go ahead and obey those more restrictive orders until further notice. Now, with respect to some additional exceptions, other than the exceptions for businesses that we need to survive day to day, like grocery stores, there are also exceptions to the order that cover what are called federal critical infrastructure sectors. And I've put the definition up at the top of the screen there. These are basically the systems and assets and companies that we need to function, the basic needs that we need to function as a society. The president's guidance, President Trump's from earlier in the week, is that if you are working in or you are one of these critical infrastructure industries, that we expect you to remain open and coming to work because you have a special responsibility to maintain your normal workflow. Those sectors are listed on this page. Okay, and you'll notice they're all ones that you would probably assume would be critical sectors at a time like this. So defense, industrial base, the energy sectors, we can keep the lights on, the dam sector so we can keep the power flowing, food and agriculture sectors so we have something to eat, all of these sectors. Now, in order for you to determine whether you as a company fall into that, we have included in a handout a document from the federal government that provides more guidance as to whether particular companies are considered part of these sectors. So I would encourage you to download that guide, take a look, and see if it applies to you. You can also review the website listed on your slide right there. That will give you more information regarding what is considered a critical infrastructure or sector or infrastructure during this time. So assuming that you qualify as under one of those sectors or you are otherwise remaining open, we wanted to spend some time going over some remote working arrangements. Companies such as ours, our law firm, we are doing the best we can to work remotely. It raises a number of important legal issues from the standpoint of how we need to treat our employees, pay our employees, and reimburse them. So to the maximum extent possible, have your employees work remotely if they can, okay? With respect to your non-exempt hourly employees, if you are going to have them work from home, and if possible, I would encourage you to do that, it's critically important that you make sure that you have them record all of their hours worked, just like if they were in your office. They need to record their hours worked and their meal periods taken. You also should have them acknowledge in writing that they've taken all of their required rest periods. The point of all this is that just because they're working at home, it doesn't change our obligations as California employers to record their hours worked, to make sure they're taking their meal and rest breaks or having the opportunity to do so. If you use electronic timekeeping and you can have your hourly employees use that from home, excellent, you should do that. If not, if the best thing you can do is a paper timesheet that the employee fills out and signs, that is the second best option, and you should definitely do that. What you should not do is not have any system. Make sure as well that those hourly employees understand very clearly that they're not to do any work off of the clock. They need to be on the clock just like they are when they are working in your office or at your normal business location. Now, as employees are working from home, they're obviously going to need to use particular equipment in order to accomplish those objectives. Things like computers or laptops, printers or phones, internet access. To the extent that you can, we recommend that you provide all of that necessary equipment to them. The reason that is important is that to the extent that we have employees provide their own equipment, Labor Code Section 2802 requires us to provide a reimbursement to those employees for the reasonable cost of the use of their personal equipment. And so, for instance, if you are having employees use their own laptops and their own printers, we need to arrive at some number which reasonably approximates the value of your business's use of that equipment, and we need to pay that to the employee as an expense reimbursement. This frequently...
And go ahead, this is Ted Bacon. I just wanted to add to that, again, that doesn't have to be exact to the penny. If you have people that do telecommuting at this point, you may already know that if, for example, if an employee uses their personal cell phone and they are a non-exempt employee or even an exempt employee and they use their personal cell phone, you can estimate how much of the use of that cell phone is business versus personal related. And so if the phone bill for the month is $80, you can estimate it, and you can go ahead and set a number like $45 or so for business use and $35 for personal use, and then you can go ahead and just pay them that amount as long as it approximates what the amount is. But you probably need to do that if you're having them work from home and they're using their own internet provider service to log in. You probably need to allocate a certain portion of that to business use as well, and set a payment to those telecommuting employees on that. It is an area that certainly it again is also an area that overall all these things Jonathan has said is best to have if you have telecommuting employees. Best to have all this in writing and all of it laid out, setting forth specifically, you're obligated to take a meal period, you're obligated to take your rest period, you're obligated to, if you're using this is the amounts we're going to agree. And if you think that then that's not reasonable, you need to let us know. All of those kind of things are very important if you're having telecommuting employees.
Yeah.
Thanks, John. Just want to add that in.
So, absolutely. Next issue that comes up frequently is if we are going to remain open as a business, chances are you are not going to be able to employ the same number of people as you're doing so right now. There's three basic options that are available to you as an employer. We want to spend a few minutes going through those, sort of reduced hour arrangements, reductions in force or layoffs, and then furloughs. And so first of all, reductions in hours, just like it sounds, that's a reduction in your working hours and pay for some or all of your workforce. So if you're deciding to do that, that's an option. We're going to spend some time on that. Reductions in force, those are, I put this in quotes, but those are permanent layoffs of some or all of your employer's workforce. So you're laying off 10% of the workforce or half the workforce or all of it. We call that a RIF, a reduction in force. And finally, a furlough, which is basically like a temporary layoff where you are not committing to permanently lay off the affected employees right away, but you are telling them that, look, we don't have work to give you. We are not terminating you, but we are putting you on furlough. Hopefully, if things get better, we will be able to bring you back. It is without pay. So let's spend a few minutes and break down these three different categories. For reduced hours in situations, you are, as an employer, permitted to reduce your hours and pay as necessary for your employees. You can absolutely do that. For your hourly employees, it is very simple. You can simply cut their number of hours each week and then also cut their hourly rate prospectively. So we can never cut hourly rates for work that has already been performed by your employees. But if beginning on Monday, you want to tell your hourly employees, I'm sorry guys, but we're dropping you all to minimum wage or $14 an hour or $15 an hour, you can do that prospectively. For your exempt employees, those are your employees who are paid on a salary basis and they don't receive any overtime. It gets a little bit trickier. The labor commissioner for the state of California has informed us that you may temporarily reduce an exempt employee's salary and their hours due to an economic circumstance such as COVID-19. The thing to keep in mind, though, is that as you reduce those salaries, make sure that you don't reduce them so far that they no longer meet the minimum threshold for salary exempt status. And so if you're a small business, 25 or fewer employees, you need to pay those salary exempt employees at least $49,920. If you're a larger employer with 26 or more employees, you need to pay them a minimum salary of $54,080. The point of this,
yeah, go ahead, John, and then I'll add one more thing.
The point of this situation is that the state recognizes that in emergency situations, these temporary reductions in hours and pay for exempt employees is permitted. But once the emergency has passed, the labor commissioner requires that we promptly restore those employees to their previous salary positions if possible.
The one thing I wanted to add regarding exempt employees is you've got to be very careful that if you are going to reduce an exempt employee's salary, that you also objectively, very clearly reduce what they have to do. So, for example, if you had an exempt employee who is a manager and he manages 5 stores, and he manages 5 stores in a week, and you're now going to say, okay, I only need you to work 4 days a week instead of 5 days a week, you'll need to drop it down so that he only reviews 4 stores instead of 5 stores. You can make a correlation between the amount of work they're doing and the reduction in their pay. Because if they're doing the same amount of work and only working 4 days, you cannot reduce their pay. That the labor commissioner will come down hard on that. So be sure that if you are reducing the amount of pay for an exempt employee, that you also have an objective basis to establish that you are also reducing in the work that they need to do.
Yeah. So in addition to reduced hours, we can also talk about reductions in force and furloughs. Reductions in force where you're laying off a chunk of your employees, and furloughs where you're basically putting them off of work, they implicate federal and California WARN Acts. WARN stands for Worker Adjustment and Retraining Notification Act. These are laws at the federal and at the California state level that generally require us to give 60 days advance notice prior to any what we call covered plant closing or mass layoffs. So if you are letting go of a large enough number of employees, under this law, under normal circumstances, you're required to give 60 days advance notice to both the affected employees and to certain state and local agencies. And the intention behind the act, the intent of the act, is to allow the employees time to find other jobs and also allow the state an opportunity to come in and provide unemployment and other reemployment services to those employees before they're just flat out of luck. Now, the federal WARN Act, and we're just going to spend a few minutes going over each of these separate statutes. It applies to what are called covered employers, and it's generally those with 100 or more full-time employees, so what we would consider larger employers. It covers mass layoffs and plant closings that meet certain numerical thresholds. If you are contemplating a furlough of less than 6 months, under federal WARN, that does not count as a mass layoff or plant closing, generally speaking, and you would not be required to give WARN Act notice. Now, there are some exceptions and some safe harbors to federal WARN Act. If you have to order a mass layoff or plant closure due to business circumstances that were not reasonably foreseeable at the time that notice would have been given, fine. The law requires only that you provide as much notice as is practicable, or if there has been a natural disaster, say an earthquake or a flood, and it has shut down your business, then you would not be required to give the WARN Act notice for the full 60 days, just as much as is practicable. You'll notice at the bottom of the slide, I highlighted in red, COVID-19, very likely, I would bet the farm that it would qualify as an unforeseen business circumstance under in these cases, just because of the nature of the threat, how quickly it is set on, and how drastically it has impacted our economy and our lives. California WARN Act, unlike the federal WARN Act, we apply it to what are called covered establishments, which are defined as any industrial or commercial facility that employs 75 or more persons within the previous 12 months. So if you have a covered establishment, then you would be covered by the California WARN Act. It covers what are called mass layoffs, relocations, or terminations of 50 or more employees. It does not, unlike the federal WARN Act, it does not contain an exception for furloughs. And there has been some recent case law from back in 2017 and 2018 stating or suggesting that a furlough would qualify as a mass layoff under California WARN. Now, as with federal WARN, California's WARN Act does have some exceptions. If a physical calamity or an act of war occurs, then the full 60-day notice period does not need to be provided. It's unclear sitting here today whether COVID-19 would qualify as a physical calamity. Again, those usually refer to things like floods, fires, and earthquakes, things like that, a meteorite hitting the earth. In addition, if a company is faltering and is actively seeking capital or business in order to survive, and if it can show that it would be unable to secure that financing or business if it was forced to provide that WARN Act and basically broadcast to the world that it's a faltering business, then it would not be required to give the full notice. These are very technical exceptions, and you should, before you take advantage of them, you should definitely seek legal counsel. Now that I've scared you, let me give you some good news about California WARN Act. On the night of March 17th, 3 nights ago, Governor Gavin Newsom issued another executive order, N31-20. What this order did, among other things, is provide relief from the requirements of the California WARN Act. So for the period beginning March 4th, which is when Governor Newsom initially issued his first state of emergency, until the end of the declared state of emergency, significant portions of the California WARN Act are suspended for employers who have to order mass layoffs, relocations, or terminations at their covered establishments. It is not a full suspension. There are still 2 or 3 requirements that you need to comply with in order for you to take advantage of this. You need to first verify that the mass layoff or termination was due to COVID-19 circumstances and that they were not reasonably foreseeable as of the time that the normal 60-day notice period would have been given. That is, frankly, a given under these circumstances. I cannot foresee a situation where an employer could not verify that. You, second, need to give as much advance notice as is practicable. And at the time the notice is given, provide a brief statement of the basis for reducing the notification period. So just to give you an example, for the last 2 days, I have done almost nothing else but give WARN Act notices, provide them for clients who are doing that work to try to take care of their businesses. Essentially, what those notices are saying is, especially, for instance, on the 18th of March, the notice is being mailed out to or hand delivered to the employees and mailed out to the various relevant agencies, saying we are furloughing or terminating, we're ordering a mass layoff effective either immediately or the very next day. We cannot wait due to the nature of the emergency, and so we are giving this notice with as much notice as possible. Finally, for that notice, you need to include some language that the governor included in his executive order, and I've laid that out at the bottom of the screen here. It's in red and it's quoted. The point of that language is to make sure that your employees are aware that they may be eligible for benefits under unemployment insurance, and providing a link to the website where they can obtain further information regarding those rights. So on the subject of unemployment insurance, I want to spend some time talking about UI, unemployment, as well as disability insurance and paid family leave. All 3 of these benefits are potentially available to your employees who are impacted by COVID-19. Let's start with unemployment and disability. So if you as an employer are unable to work due to having been exposed to COVID-19, so in other words, you've been physically exposed to the disease, you may file a disability insurance claim, right? Not an unemployment claim, but file a disability insurance claim. Those benefits generally range from $50 to $1,300 a week. If you, on the other hand, have not been exposed, but you've had your hours reduced, or you've lost your job, or you're missing work due to a school closure for one of your children, you may file for unemployment, and those benefits range from $40 to $450 a week. Now, with respect to both disability insurance and unemployment insurance, there is normally a 1-week waiting period from the time that you file your claim until the time you start getting paid. The governor's executive order has waived that 1-week unpaid waiting period requirement. So it may take 2 to 3 to 4 weeks for you to get that first check, but it will pay you from the date of the date you make your claim. And just parenthetically, I will tell you that we've had a number of discussions with the unemployment insurance, with the EDD and the other agencies that deal with unemployment and disability. And to the extent you can, do your applications online. They are overwhelmed at the moment. They've never seen this many unemployment claims filed before, and so they're doing their level best to get those claims processed. But the best thing that you can do is get online, get that filing made, and you should tell your employees that, get that filing made so that it gets into the system. So in addition to UI and disability, we have something called paid family leave in California. So if you're unable to work because you're caring for an ill or a quarantined family member with the COVID-19, you can file for paid family leave. Paid family leave generally provides up to 6 weeks of benefit payments to those eligible employees. And just as with disability insurance, the benefit level is roughly $50 to $1,300 per week per incident. Now, for employers out there, if you are considering entering into some sort of work sharing arrangement where you're going to be reducing employees' hours, you may be able to take advantage of the EDD's work sharing program. And what this program does is it allows you to seek an alternative to a layoff by retaining your employees by reducing their hours, say cutting their hours in half, and having those wages partially offset by the unemployment, by the EDD, by the unemployment insurance program. You first have to get approved to participate in it, and the benefit amount is based on the percentage of hours and wages reduced. It's not to exceed 60%. You need to contact EDD, and I've provided the link for you to do so. Unlike with the unemployment insurance, disability, and paid family leave programs, our conversations with the work sharing program have not gone well. They are incredibly overwhelmed. In a couple of conversations, I was informed that a lot of these forms are being filled out in paper and requiring wet signatures. And so if you wish to take part in this program, go ahead and begin the process, but know that it may be a long and cumbersome process for you to get through. Now I'm going to turn it over to Ted to talk about some changes at the federal level.
And I want to kind of give an overview in terms of these provisions. There's basically two provisions: the Emergency Family Medical Leave Expansion Act and the Emergency Paid Sick Leave Act. These two policies, these two key provisions, dovetail into each other, and you'll see as we go through them that the first one, the Paid Sick Leave Act, is designed to cover a period of time of approximately 10 days. And coincidentally, the Emergency Family Medical Leave Extension Act says, oh, you don't have to pay anybody for the first 10 days. But of course, they can get paid under the Paid Sick Leave Act under certain circumstances. It is, I will say overall too, that as you see how the law is laid out, what the design of this law is so that employers, this is only employers with 500 or less employees, employers take on the role of paying out workers who are unable to work, who are either not laid off, but I mean workers who have their hours reduced or are no hours reduced, but are unable to come into work because of either a quarantine or a COVID circumstance, or a situation where their child is at the skilled care facility has been closed and they have to stay home with their child. So let's go and see how this all fits together. And what they're doing basically is saying, look, you employer, you've got to pay for these people and provide them a certain amount of benefits right now when the situation happens. But down the road, next year, when it gets time to pay your taxes, we'll basically pay it all back to you in the form of a tax credit. So it's nice that the government is giving a tax credit and will pay for this. It's not nice that they're asking these small businesses to front load most of the money. So let's go through the Emergency Family Medical Leave and Expansion Act. This provision is directly related to COVID-19. It applies to employers with fewer than 500 employees. And unlike the normal Family Medical Leave Act, it applies to employees who have been employed for at least 30 days. Generally, a family medical leave requires the employees to have worked for your company for at least 1,250 hours. Not so here. Anybody that's an employee, temporary employees, part-time employees, if they've been employed for 30 days, and it does not have to be consecutive, those employers are eligible for this emergency family medical leave. What it does is it allows you to get 12 weeks of leave because of a qualifying need related to a public emergency. Well, what's qualifying need? This is where it really expands FMLA. FMLA, most of you probably know, deals with if the employee has a serious medical condition, or the employee has a father, son, close family member that has a serious medical condition. This now says that it doesn't even have to be a medical condition at all. It can be that the employee is unable to work because they need to the leave to care for a son or a daughter under 18 years old if the care facility has been, or the school has been closed, and is unavailable, or the provider, the child care provider is unavailable due to a COVID quarantine or shelter in place type rule, such as we have in place now. And then the employees must provide notice as soon as practical when they need their leave. And as it says here, the first 10 days of the leave will be unpaid. Take note of that when we get to the sick leave portion. But an employee may elect to substitute accrued vacation, personal leave, or sick leave. So your employee can say, okay, look, I'm not going to, I'm going to take these 10 days. I'm going to apply for this family medical leave, and it's going to be for the next 12 weeks. And I'm doing it because my child, I can't come to work because I've got to take care of my child. And during these first 10 days, I want to use my vacation pay or a combination of that and sick leave. But note that you as the employer cannot force them to use their sick leave or their pay for that 10-day period under this particular law. So the first 10 days, it's unpaid unless the employee decides to use some of their benefits, and we'll get to the other benefit later. But after the 10 days, you must pay. Unlike normal family medical leave where they just get time off and they don't get paid, you as the employer must pay their during the remaining 10 weeks of the leave. The pay rate is 2/3 of their regular rate of pay based on the normal hours the employee normally would be scheduled to work. So again, let's remember, this doesn't come into effect until April 2nd. So it's not in effect right now. But if today your employees are working 40 hours, then it's 2/3 of their pay for that 40 hours. If, however, you went to a reduced schedule between now and April 2nd, then it would, and maybe they were only working 60 hours, then it would be 2/3 of their regular pay at 60 hours a week, because it's based on when they're normally scheduled to work. But if they're normally scheduled to work at the time they apply only 60 hours, that's going to be different. And if there's irregular hours where they're not doing it consistently, then there's a formula that comes into play. There is a cap on it in all cases. You don't have to pay more than $200 a day or $10,000 in total per employee. So there is a cap. And employers with 25 or more employees are obligated to restore their employees to their positions following their return from leave. Less than 25 employers, you must reinstate unless certain conditions are met. And these are conditions that have not been promulgated yet. They may exclude healthcare providers and emergency providers. They may exempt businesses with fewer than 50 people from having to supply that leave. That just hasn't been done yet. We'll see. So going on, this act provides for emergency paid sick leave in the case of certain absences. Again, only fewer than 500 employees. And we want to go through how you qualify for this if you're an employee. And you can see there's 3 boxes: subject to federal or state quarantine, has been advised by a doctor to self-quarantine, or is experiencing symptoms of COVID-19. Let's lump those 3 together because you'll see there's some distinction there. Those are all basically the ones that deal with the sickness itself. You either have it, you've been advised by a doctor to self-quarantine because of exposure to it, or you're caring for somebody who is subject to a quarantine order or who has been advised because they have it or they need to self-quarantine. So those first 3 all have to do with some tie into the disease itself. Either you have it or you're dealing with somebody that has it or caring for somebody. The next one has nothing to do with the disease other than the fact that if the governor has, or as he is in this case, said schools are not going to be open or a school has closed or whatever is that, and you now need to take care for your son or daughter because the school or their child care provider is no longer available, then that person also qualifies for this emergency paid sick leave. And what is this emergency paid sick leave? It is basically 10 days of sick leave pay. So it fills in the gap that arises from the prior law being the 12 weeks of leave except for the first 10 days. There's another qualification. You can qualify for it if you're experiencing any other substantially similar condition. That's one of those, somebody threw in that law, nobody knows what it means, and nobody has defined it, and so there's nothing really we can do about it at this point. Now, here's why it's important to know what reason you're doing it for. If you're eligible for the paid sick leave, you get up to 80 hours of paid sick leave. Again, 10 days. They're filling in the gap for those 10 days where the emergency FEMLA law does not cover you. And so they're equal. The part-time employees, everybody gets, the part-time employees, you prorate it based on the average hours they work over a 2-week period. So if you got a part-time person that works 25 hours a week, they're going to get 50 hours of paid sick leave. The paid sick leave is paid at the employee's regular rate of pay. If they're caring for a family member, they're entitled up to 2/3 of the regular rate of pay. So again, if you're sick yourself, you get full pay. If you're caring for a family member who's sick, you get 2/3 of your rate of pay. There is caps on this as well. Again, it's $511 per day if it's based on one of those first 3 situations where you have the COVID-19, you're suspected of having it, and you're quarantined, or you're caring for somebody that's quarantined. So that's up to $511 a day. If, on the other hand, you're simply caring for your child who is the child care is not available and or their school is closed, then it's a cap of $200 a day. So put this together between the Paid Sick Leave Act and the prior emergency FEMLA extension, you can have an individual as if they are one of your workers, if they have not been laid off due to a reduction in force, as of April 2nd, those employees can say, look, I can't come into work because my child can't go to work, and so therefore $200 a day maximum under the Paid Sick Leave Act, and then $200 a day for the next 10 weeks based under the other emergency FEMLA extension. It's got to be offered in addition to any other kind of leave that you may have on your policy, and you can't change your policies between now and April 2nd to eliminate. Like, for example, if you had a policy that said all employees that go on FEMLA are entitled to 1 month's worth of paid time. This would be in addition to all of that, and you'd have to pay that too. And you can't eliminate a policy that you've had under that situations. You can exclude, again, healthcare providers and first responders under that leave. And as I said, there is a tax credit that goes with these new federal laws. And so because of that tax credit, in the end, the government federal government is making it, saying basically, we want all of you to front all this money, but on the back end, we'll give it to you in a tax credit. So essentially it will be no money out of your pocket. The problem is it's all the money out of your pocket as an employer now, and you don't get that tax credit till it's time to file your tax returns in April of 2021. So, and corporate returns would be later than that. So it's a very difficult thing to deal with, and it's a very expensive thing. All I can say is if you're contemplating doing a reduction in workforce because you just don't have enough work, better to do it before April 2nd, because if they're not employees at that time, they're not going to be entitled to this benefit. If you need to keep them on because you think you're going to be able to get back to work, or you're one of those companies that is performing essential functions, and you're going to continue to work, and you need to keep them on, then just be aware that this may be a cost of continuing to do business. We've also put here on this, for more information, the California coronavirus website, federal government's website, and the CDC's prevention website, all of which are great resources for going forward. And now we're going to go into another area because we had planned on this before the governor shut down the state, basically, And so there's a lot of other issues that arise if you're continuing to operate. And some of you may be in companies or businesses that are allowed to operate, construction companies or other essential industries that are part of what the federal government has called the critical infrastructure component. And again, those are defined in the handout that is attached. In those cases, you might have these other situations arise, or perhaps down the road, you might have situations where the governor lifts the restrictions and allows people to come back to work, and now but you still have situations where you have people with lingering COVID-19 issues or things like that. And so all these other things that were very, very relevant yesterday may come back into play if you're in one of those two categories. So Jonathan's going to kind of briefly run through some of these. And again, you'll have this available to you, the whole outline, so that these will be available for you down the road.
Right. Thank you, Ted. So first, when it comes to if you are operating your business during this time, we got to prepare your workplace and your workforce for COVID-19 related issues. So hygiene is key. We recommend you post the CDC approved posters regarding proper hygiene throughout your office. For employees who are working at your office locations, require hand washing with warm hot water and soap every time they show up at work, and whenever they leave and come back, every time they come back into your building or your facility, make sure that they're washing their hands throughout the day. I know hand sanitizers are pretty much worth their weight in gold right now, but to the extent that you have them, provide hand sanitizers to your employees, as well as tissues and no-touch disposal cans. With respect to hand sanitizers, I'm aware that the California state has basically authorized various distilleries because some of the refuse from the distillation process can actually be used as a sanitizer. And so, for instance, the County of Orange is basically buying up a lot of that remaining byproduct from distillers here in Orange County, which they're then converting into hand sanitizers, in which they're making available to emergency medical personnel. But again, if you have hand sanitizers, make them available. Provide tissues so that employees don't have to physically touch door handles when they open them and close them, and provide some kind of disposal can where they can dump those tissues. Routinely clean all the surfaces in your workplace. So anything that's frequently touched, doors, door handles, refrigerator doors, things like that. If you operate with a shared office or a hot seating arrangement where you have multiple people using a particular workstation, or you have a receptionist who switch in and out of the receptionist station, all of these employees need to wipe down the phone, keyboard, mouse, and other work surfaces anytime they're surrendering that workplace, that workstation, to another employee. So anytime you switch up receptionists or you switch up the hot seats, the employee who's leaving needs to make sure that they wipe everything up. In addition, no sharing of personal items between employees, things like brushes or dishes or cups, anything like that, as well as food. No food sharing, just like in elementary school nowadays where they don't want the kids trading food amongst each other. We don't want to be doing that in the workplace right now. What about your business operations specifically? And this goes without saying, but to the extent you can, you should stop all business travel unless it's absolutely necessary. Stop all business meals with customers or clients or vendors or counterparties, or in-person meetings unless it's absolutely necessary for your business. In addition, because we're sort of treating, or you're trying to create a safe zone or a clean zone within your own office environment, you want to limit meetings in your office unless they're absolutely necessary. For your personnel that are working on site, it's important that you cross-train them so that if someone has to go out sick, or if you've decided to further reduce in the office to limit exposure, that the employees who remain are cross-trained on the basic functions of the jobs of the individuals who are being sent home or who are leaving. And in this regard, use technology to your advantage. So with respect to remote work, and we'll get to that in a minute, online meetings like Zoom, GoToMeeting, Slack, whatever those options are, take advantage of them. We have had, just so you know, GoToMeeting and GoToWebinar, we've had some significant snafus today with them because they're frankly overwhelmed, but I imagine that they are going to increase their capacity in the coming hours and days, and hopefully be able to make more of their service available to more companies so you can keep the business going and the doors open. Now, the next part of this presentation, we want to talk about What you can and cannot ask your employees about their coronavirus experience. This is important because we have a continuing duty as employers to maintain a safe and healthful work environment for all of our employees. So how much information can you request from an employee who calls in sick? So during a pandemic, you as an employer may ask those employees if they are experiencing symptoms of the virus. So you can, if they call in sick, you can say, okay, Steve, are you experiencing symptoms of the virus? And for COVID-19, we've listed the main symptoms here. So fevers, chills, coughs, shortness of breath, sore throat. While you may ask your employees about this, you do need to maintain it as confidential because it is a confidential medical record. Another question we're frequently getting is, what about our ability to take body temperatures of employees? While those measures are generally considered medical examinations under the law and therefore tightly restricted by employers, because the CDC and our state and local health authorities have recognized that community spread is a real threat with respect to COVID-19, employers may take those measurements. You may take body temperatures of your employees. It's a helpful tool. It is not a foolproof tool, because remember, there is a certain percentage of people who are infected with COVID-19 who are asymptomatic. Asymptomatic simply means that they carry the virus, but they don't exhibit any of the symptoms of the virus. So they could be walking around and they may not even know that they have it, but they carry the virus and are potentially able to spread it to others. Can you as an employer require your employees to stay home if they do have symptoms? Yes, absolutely, and that is absolutely what the CDC wants you to do. So if employees are ill or with symptoms, they should leave the workplace immediately, and they should go home and self-isolate unless they fall into one of the risk categories of elderly employees or employees who have compromised immune systems or who are severely sick and need to go to the hospital. The point of that is for most people who come down with COVID-19 and who exhibit symptoms, they will not be too severe and they can be treated at home. The CDC is trying to keep as many hospital beds open with ventilators available to people who truly need them. So, next question, can you as an employer require a doctor's note or a fitness for duty certification? Yes, if you have an employee who has exhibited symptoms, they've stayed home for the 14 days, they've been cleared to return, you can request a doctor's note or fitness for duty certification before you allow them back in the workplace. Having said that, doctors and hospitals are overwhelmed at the moment, and they're going to become even more so very soon, most likely. And so they may be too busy or unable to provide an in-depth certification that we would normally require in any other circumstance. In those cases, we should consider relying on other alternative forms of certification. These are things like a form signed by a local clinic, a stamp or an email or other document that certifies that that individual does not have the pandemic virus anymore or never did. So keep an open mind and be flexible about those certification requirements. What about your employees if they have a family member who's traveled to one of the affected areas? So let's say they were in Iran or they were in China or South Korea. You as an employer may request that those employees inform them if they have had a close contact with any family member who's traveled to a high-risk area. So you can ask, do you have any family members who've been to a high-risk area, in order for you as the employer to determine if that exposure poses a threat to the health and safety of others. Okay? Can you prevent employees from traveling even if it's for personal reasons? Short answer here is no. Employees are allowed, if it's on their personal time, to travel pretty much where they want. There is a caveat to that. You as an employer should advise those employees who are contemplating such travel that they may be subject to quarantine upon their return if they exhibit symptoms or if they've been traveling to regions where the virus is particularly virulent. So for instance, Seattle or New Rochelle, New York, which are both epicenters of the virus in the US. Can your employees refuse to go on business travel? So if you are telling your employees that you need them to drive up to Bakersfield to meet with a customer or a client, can they refuse that business travel? The answer to that is maybe. It gets a little complicated. If an employee is part of a group of other employees who are objecting together to being requested or being required to conduct business travel, they could be protected by the National Labor Relations Act. Its protections against are in favor of concerted protected activity. What concerted protective activity is is this concept in federal labor law in relation to the union environment, where employees, if they are banding together to assert their rights or protect themselves from violations of their rights, they're protected in those activities. So if you have a group of employees who are coming to you, do not automatically say that I don't care and you guys are all going or else. It's better for you to stop, take a breath, try to work out a solution where you can get people, get coverage up at those business meetings. But if you are going to decide that you want to go ahead and terminate, I strongly urge you to consult legal counsel before you do so. Now, another question we get, what if your employee appears ill, but they refuse to leave your workplace? So they may exhibit symptoms like a fever or a chill and they're refusing to leave. Simple answer, you need to explain to that employee that the public health nature of this risk is such that they must leave the office. Okay, and you should offer to let them use whatever paid sick leave or other leave benefits they have, but you have the absolute right as the employer, if you have an employee who's exhibiting symptoms, to tell them you need to leave the office right away. Now, I have gotten a few of these questions, which are very atypical at this time. But if you are actually in the process of hiring applicants, so for instance, I know Amazon is in the process of hiring up to 150,000 drivers because their service, the demand for their service has gone through the roof. If you're an employer who is in that fortunate position where you're hiring, can you screen applicants for symptoms of COVID-19? Yes, but you first need to make a conditional offer of employment to that individual. In other words, you need to present them with a written job offer that says, I am offering you this job, say as a driver, for 20 bucks an hour, but it is only, it is conditioned upon you passing or testing negative for COVID-19 or not exhibiting any symptoms of COVID-19, okay? Can you take an applicant's temperature as part of that post-offer pre-employment medical examination? Yes, just like with your regular employees, you can conduct those temperatures. Keep that information private. Can you delay an applicant's start date who has COVID-19 or related symptoms? Yes, according to the CDC, just like with employees who present in the workplace with symptoms, they should not be there and you don't want them in there. So the answer to that is yes. Can you withdraw a job offer when you need an applicant right away, but the individual you offered a job to has COVID-19 or related symptoms? Yes, this is based on current CDC guidance. Since those individuals cannot safely enter the workplace without exposing others to the threat of infection, the employer therefore may withdraw the job offer in that limited circumstance. Anytime you are engaging in that kind of a revocation of a job offer, I strongly urge that you do so in writing. Next, what happens if you have an employee who shows up to work sick? Okay, a lot of this is commonsensical, but we'll go through it. Send the employee home right away. Before that employee leaves, find out from them who they've worked in close proximity with over the last 2 weeks, the last 14 days. That's important because that's the recognized incubation period for COVID-19. You should never identify that infected employee by name because that's private medical information. However, you should take the information you receive from that employee and send home all of those employees who work closely with that individual for their own 14-day period to ensure that they are not infected and are not spreading COVID-19. In addition, you should contact your local health departments, that's usually the county, at least in California, and provide that information above. They need that so that they can do tracing work to try to find out who that employee may have interacted with so they can stop the spread. Countries like South Korea and China have been incredibly successful using geolocation services and cell phones in order to do this tracing work to try to get a handle on the virus. There's been talk, and unfortunately, the federal government is moving at a very slow pace, but there are efforts underway for us to implement a similar kind of geolocation tracing capability for the federal government. In addition, when you send that employee home, obviously clean and sanitize the office and consider the direct threat under the ADA. So in other words, COVID-19, because it is considered a direct threat under ADA, you need to consider whatever steps you think are necessary and reasonable in order to protect your employees. And remember, some employees are asymptomatic. Again, they have the virus, they may have the virus, but not exhibit any of the symptoms of the virus. So keep that in mind. Now, this is a question that we've actually gotten several times this week. What if an employee refuses to come to work? So they call up and say, you know what, governor's issued this emergency order. I don't feel comfortable. I need to stay home and with my family. Generally speaking, under the law, an employee can only refuse to come to work if they believe that they're in imminent danger of infection or harm. The threat must be immediate or imminent, and their objection to coming into work must be objectively reasonable under the circumstances. Now, even in the face of the COVID-19 virus, most workplaces in the U.S. do not meet that high threshold. This is particularly the case if you as the employer have taken those necessary steps that we've talked about to sanitize your workplace, to have a certain number of employees work from home remotely so that you have plenty of social distancing between your employees. In most cases, in that circumstance, you can, as an employer, say, you know what, I appreciate your concern, but we do need you to show up to work. Now, having said that, if you have a group of employees jointly refusing to work, this is very similar to the situation we previously discussed surrounding business travel. That may raise some National Labor Relations Act protected concerted activity issues, and we need to explore that more fully before we take any drastic action. In those circumstances, employees who are acting together are generally protected against discipline or termination for engaging in that kind of conduct. Now, at the bottom, you'll see in red, it says stay tuned. This is because many jurisdictions they have or they're about to issue further stay-at-home orders, even above and beyond what Governor Newsom has ordered. Those could potentially justify an employee's refusal to come to work, especially if they do not work in an essential service or if they do not work in one of the essential sectors as identified by the federal government. What about use of paid sick leave or paid vacation or PTO benefits that you as an employer may provide to your employees? So can your employee use paid sick leave due to COVID-19? Yes, absolutely. That employee can request or the employer can require it when the employee is out due to their own health condition or that of a family member. You can require them to use that up. Now, if your employee has exhausted their paid sick leave, can other paid leave be used? Short answer is yes, provided that the terms of that vacation or other paid time off policy permits it, okay? FMLA and CFRA, the Family Medical Leave Act and the California Family Rights Act have separate requirements that permit the substitution of paid vacation or PTO benefits, so keep that in mind. If you as an employer require an employee who is not sick but under quarantine to use their paid sick leave? The answer is no. If they're not sick, they're simply under quarantine, the employee's use of the paid sick leave is at their discretion. Okay, that's an important distinction to keep in mind. Now, what about situations where your child's school is closed or their daycare facility is closed for reasons related to the pandemic? In these circumstances, they may use their paid sick leave or other paid leave that's available. Keep in mind that in California, we have a state law that applies to employers with 25 or more employees that permits them to take up to 40 hours per year for school-related emergencies. And a shutdown due to COVID-19 is a perfect example of one such emergency. You can require employees to use their paid vacation or paid time off benefits for those leaves. You cannot require them to use their paid sick leave benefit in those circumstances. Now, if an employee reports to work but is sent home due to illness, are they entitled to pay? This is getting to the issue of reporting time pay. So if you have an employee who shows up to work, it's a normal, well, all things being equal, a normal work day, they show up to your office to work, but you can't furnish them their full work shift. In fact, you can't even furnish them with half their work shift. If they report to work and they're furnished less than half their usual hours, so let's say their work shift is 8 hours, and they show up to work and you can only give them 3 hours of pay, you must compensate them for at least 2 hours, but no more than 4 hours of reporting time pay. It's called reporting time pay. If a state of emergency is declared, however, the reporting time pay rules may not apply. So if a state of emergency does not recommend discontinuing business operations, then reporting time pay applies. If the state of emergency from the governor or the local agency says, we are recommending discontinued business operations, no reporting time pay is required. So a good example of this is if you have an employee or a company that operates in the essential services, let's say you operate a gas station or a laundromat, The declaration, the state of emergencies that have been declared have not ordered the closure of those businesses. So if you have an employee who comes to work and you're not able to furnish them with at least half their usual shift, then the reporting time pay rules would apply. If you are one of those businesses that is not part of a essential service function or a component of the defense sector, for instance, and you have an employee who shows up and your business is being discontinued by order of the state, you do not have to pay reporting time pay. And the idea there is that it's truly beyond your control. The government is actually telling you not to open your doors. Final question we get: if you have an employee who's salary exempt, so they're exempt from overtime, are they entitled to a full week's salary for work interruptions during a work week due to a shutdown of operations? Short answer to this is yes. So the idea here is that your salaried exempt employees receive a set salary with no overtime. They're paid essentially for the quality of their work, not the quantity of their work. And so if they work any portion of a work week, then they need to be paid their full salary for that work week. The corollary to that is that if that exempt employee performs no work at all during a work week, then they are not entitled to their weekly salary for that work week. There are certain rules in place in California and at the federal level dealing with situations where an exempt employee is absent from work for less than a full day for reasons of illness. In those circumstances, you may not reduce their salary, but you may take time away from their paid sick leave bank to cover that. However, if they have exhausted all of their paid sick leave and they're absent for part of a work day, they still need to be paid for the full work day. I'm again putting this card up. This is our last slide of the presentation. Again, if you have any questions, please direct them to webinarquestions@alvaradosmith.com. Please direct them to that address. We will do our best to respond to them in a timely fashion. Unfortunately, given the nature of this situation, sometimes it is not possible to give a precise, foolproof answer to all of these questions. We're really dealing with an unknown situation that's frankly unprecedented. And so your obligation as an employer is to do the very best you can under very difficult circumstances and try to get through this process.
And we want to thank everybody for participating in this webinar. We hope we've given you some good information, and we'll all do our best to get through this together. So thanks again for participating.
And we will have a copy of the recording available. If you wish to have a copy of it, please send us an email to webinarquestions@alvaradosmith.com, and we'll do our best to get that to you. Thank you very much.
Thank you.